Ricky here with Gavlaw. You get rear-ended by an uninsured driver while in a rental car. You do everything right. Call the cops, file a report, notify the rental company. Their insurance says the car is fixable. Your insurance pays them. Then, out of nowhere, the rental car company totals the vehicle, sells it at auction, and comes after you for the gap. This shouldn't be happening, but it is. And if you're in this situation, you need to understand your rights right now, because the clock is ticking. So let's find out. The rental
No. This is for
Gavlaw.
car insurance did an initial assessment, deemed the car repairable, your insurance paid based on that assessment, and then, without clear justification, they flipped their decision and totaled the vehicle instead. That's the red flag. Montana Code Annotated Title 28 governs contracts, and the rental agreement is a binding contract. Their sudden reversal contradicts their own initial contractual position. This flip shows inconsistency and potential bad faith. You relied on their first assessment. Their second assessment shouldn't cost you money when you weren't at fault. You were stopped in traffic. An uninsured driver hit you from behind. Under Montana negligence law, that driver is liable for the damages they caused, not you. Montana Code, Annotated 271701 ASEQ, establishes negligence principles. The at-fault party bears liability. The rental car company cannot legally shift the financial burden of the uninsured driver's negligence onto you. That's a fundamental principle of Montana tort law. Montana has a specific law against unfair insurance claims practices. If the rental car insurance misrepresented facts, changed their position without legitimate reason, or failed to act in good faith, they're breaking the law. MCA 33-18-211 prohibits insurers from misrepresenting facts and material aspects of claims. They cannot simply change their assessment mid-process without documented, reasonable justification. This law is your shield. Under Montana subrogation law, once your insurance paid for damages caused by the uninsured driver, your insurance has the right to pursue that uninsured driver, not you, for recovery. MCA 33-15-301 establishes this concept clearly. The insurer steps into your shoes to recover from the responsible party. They should be going after the uninsured driver for the gap, not you. If they're coming after you instead, they're sidestepping the proper legal process. The gap between their initial assessment and the auction price is a loss that resulted from their own decision-making, not from the accident itself. In Montana, insurers must act reasonably and transparently in claims handling. That's the bad faith doctrine. You have the explicit right to demand that they provide detailed, documented justification for why they changed their assessment from repairable to totaled. If they can't provide it, that's a serious problem for their case. Lack of documentation is your leverage. Your personal insurance already paid based on the initial assessment. Don't let them bully you into paying for their flip-flop. Get everything in writing and push back. If you're in this trap, you need to act now. I'm Ricky with Gavlaw, and we're here to help you understand your rights.